this State of New Hampshire versus Richard Paul. If I could ask the council and PPS to identify themselves for the record.
John Webb for the state. Jason Smith with probation.
Matthew Hill for the defendant.
Thank you. It's my understanding from some motions that have been filed that the state is moving to amend the violation of probation, and in response to that motion, the defense filed an objection to the amendment and argued in the alternative that if the court was going to permit the amendment, that the defense was going to be asking for a continuance on the scheduled probation violation hearing today. Am I correct in summarizing the positions of the parties?
Yes, Your Honor.
Yes, Your Honor.
And I previously indicated to counsel that that in light of that, I'm going to grant the state's request to amend the charge, but I'm also going to grant the defense's request to continue the violation of probation hearing in this matter. I mentioned to counsel that a potential date available today, we'll take up the issue of bail in a moment, but a potential date to have a full hearing on the probation violation would be July 24th. I don't know whether counsel have been able to confirm whether they're available and whether it's going to be available that date.
The state is available. I'm available, in other words. Yes. EPO is available.
And in looking at the court calendar, we could do it in the morning or we could do it in the afternoon. I don't know how long counsel anticipate for a hearing, but I think there's just a short motions hearing on in the morning at 9 o'clock. I'm happy to do it in the morning or the afternoon, whatever works with counsel.
Your Honor, I defer to the court. I can be available either time. I will say that I think it is best for us to hold a fairly substantial chunk of time for the hearing.
And in light of that, perhaps it'd be better to start in the morning in case it takes a little bit longer than most probation violation hearings do take. So we'll set it for 9 o'clock on the 24th. And now we have the issue of bail. I take it because I see some equipment being set up that the parties were not able to reach a resolution on the issue of bail.
We were not, Your Honor. And if I may, it's my belief that Mr. Webb intends to play the 11, 12-minute video in its entirety. I have a shorter portion of it. That is a 3-minute portion that I believe shows all of the relevant conduct as far as what is described in the violations. I had suggested to Mr. Webb that be sufficient. I believe he has a different position. I think that I would stand on an objection, a foundational objection to this being used as any evidence against him regarding substantive violation. I understand that he's trying to present this today only for the purposes of the bail hearing. And we're doing that without objection, is that right?
Yeah, I'd like to see him, and I didn't do anything wrong.
That's a pretty forceful statement. In light of that, again, it doesn't much matter to me whether I'm certainly willing to take the additional time. I take your primary objection to the additional time is there's information that's not terribly relevant from the defense's perspective. But does the defense object to showing the entire 11 minutes of the video?
Yes, Your Honor. I think that the first 3 minutes is sufficient to address any concern there may or may not be about some risk to the community or Mr. Paul himself.
Why does the state believe it's important to show the whole video?
Toward the end of the video, there's some conversation going on in which the defendant talks about calling other people and getting them to come down to Central Square. And so the state believes that conversation on the part of the defendant is pertinent to the issue of bail. There is a lot of dead times, I'll call it, in the video in between where there's nothing exciting going on. So I understand where the defense is coming from in that regard, but there is just a bit at the end where the defendant's talking about calling and getting people to come down to Central Square, which is, state doesn't mean to suggest that it's illegal to be in Central Square, but in light of what had just happened, a confrontation between these two groups, you know, the state thinks it's indicative or at least relevant for bail purposes. And the state recognizes that the conduct of the other parties was, you know, egregious or uncalled for. So the state recognizes that fact, but it's the stirring up of this whole thing that the state argues is pertinent to this bail hearing. The safety of both the safety of the defendant and the safety of the community is called into play, the state would argue. So I would like to play the whole thing. There will be some, we're all going to be twiddling our thumbs in between for a period of time, but I think some of it is pertinent at the end.
I'll allow it, I'll give it whatever weight is appropriate, that the objections will play the role they do. And again, by ruling on this, to get to Attorney Hill's point about whether or not on a probation violation hearing, I don't mean to suggest that I would necessarily admit it at the hearing, but really for now it's just for purposes of this bail hearing. I'm not ruling on that legal issue that has been raised by the
I understand, Your Honor. Thank you.
So I'm notoriously bad at technology, Your Honor, so pretty much sure than
I think we need more rights out to be able to tell it.